truth, logic, common sense, that gut feeling, and yes, even a little psychoanalysis, as we're once again together, you and I, to discuss Chad and Lori Daybell. Well, folks, y'all think I became a little cynical yesterday, putting on a little skit about Lori's little dreaming of wanting this case dismissed against her? Huh? You know, I just couldn't help it. You know, every time we think things are moving forward, something else drops. And at first when I read it, I was like, you know, what the hell? You know, why didn't this attorney of hers, Archie there, why didn't he bring this out last year or any other time? Right? There's some common sense things that kind of calmed me down. But I want to get through a few of your comments before we tackle this issue. You know, some of y'all really kind of concerned about this when you look at the reading of the statute and the law. So I figured, well, let's just do it. Let's just go through it. Let's set some minds at ease, because it's my view that this ain't going to do shit for Lori, all right? Archie's doing his due diligence, but I'm going to break it down the best I know how, and we'll just go through it. But let me just get through the whole announcement, you know, that Archie's filed this. He wants to have the charges dismissed because she sat in jail too long. And many of y'all reacted. Jack Fry says, unbelievable. Sandy Major says her victims have been dead for much more time than 1,169 days. In fact, they are still dead because of her evil. This turns my stomach, says Sandy Majors. Harley62 says, okay, dream on, Lori. Dream on. Oh, Madame has been in jail for over 1,000 days. Oh, it is a pity. And I am assuming that Harley62 was being sarcastic. I mean, I can't look at it any other way, and many of y'all can't look at it in a serious way at all. And I don't blame you. Mary Meadow says, if the case was dismissed, could she be rearrested and charged again? Then the case against her would be a new case, same charges. And Mary Meadow, that's a very good question. And I put in the comments, theoretically, yes, she could. But then think about this. You have to see it through. If they did, they had to dismiss it because this speedy trial thing and her constitutional rights, and then they refiled charges against her, you'd have to go through this whole damn thing again about joining that to Chad's case number. You'd have to go through all of this all over again. And, you know, it would just be a real pain in the ass. But that's a good point, Mary Meadow. Sugar Butt Starburst says, dream on, hussy. You're not going anywhere. Let her keep dreaming. Ramallah says, you should not have killed your daughter or your son. And Ramallah's talking to Lori, saying, and conspire to murder a mother of 5, wallow in sadness. The beginning of justice for the victims is when the perpetrator is trying their damn best to dismiss the trial. Get the popcorn. I'm so happy to see this, because this means she is so desperate to stop the murder trial. Cry on, murderer. You should have thought about this before the murders took place under your supervision. Enjoy your last moments before you go in a cell forever. Doris Johnson keeps it simple and says, doomsday is coming. And Doris, I couldn't agree more. I couldn't have said it better. Amazing Lynn says, 1,169 days spent in jail, you say? No court day, you say? Wow, geez, good point. Now, who in the world can blame us for that? Mike from Ohio says, this is going to be like a circus court. That Lori didn't feel her kids' lives were important, but she feels that her life is. She deserves the death penalty. Kathy Benya says, here comes the judge. Here comes the judge. She's done pissed him off now. She has been more than patient and accommodating. He has accommodating to her whims and delays this whole time. Now maybe he will get down to business and stop allowing Lori to cause any more delays. I hope Boyce hands it to her and Chad on a silver platter. Death penalty. Baby Dolph says the judge set the trial for April, so she would get her speedy trial. RD and AC says, who delayed it? Her and her lawyers with their shenanigans. Nathan Tibbs says, so will she complain about jail for a longer period of time once she is convicted and sentenced to life without parole? That will be a lot longer than the 1,169 days she's already done. Good luck, Lori. Rainy April says, what I can't understand is why didn't the prosecution see this coming? And the judge, he himself brought it up. Why did it seem like it was an issue bound to be raised and they played right into the defense's hands? A constitutional right violation is serious. Worst case, she could walk right into Arizona's custody, and hopefully they're prepared for trial more than Idaho was. But it makes a person think that the conspiracy theorists are right. Somebody never wanted to put her on trial for this because she believed in church doctrine, and she really is crazy. And Idaho has no insanity defense. Sorry for sounding so negative, but really? Something that was already brought up and they let it happen? Violation of a speedy trial? Right? Because the state didn't want to sever the cases to save money? Sorry for the rant, KJ, but my bum is burned. And Candace Parr says, it's just for appellate issues in case the witch gets the death penalty. I kind of like to see her in the regular prison population where some mothers who stole or committed drugs, etc., those moms miss their kids. Yeah, let them take care of Goldilocks. And those are some of y'all's feelings on all of this. And let me just be clear with you. All of them are relevant. All of them kind of speak to the whole concept of justice through understanding, because, again, this is about all of our views and how we see this case. One part to the next, we're looking at it, we're discussing it, and now we get to the document itself. Motion dismissed for lack of a speedy trial, says Archie. And don't you find it interesting that Archie would want to file this now? Although before he filed it, what did he file? He filed for records. The Church of Jesus Christ of Latter-day Saints, he has got those records coming to him about Lori's time in the church. Also, J.J. Vallow's educational history. If this man really thought he had a snowball's chance in hell, why do all that? Because I think everyone should know that Archie's been down this road. He's very experienced. He has to put it in there. It's just interesting to me that he would choose to do this now and not back before when he was asking Judge Boyce to toll the time. Remember that? He couldn't ask for a continuance, but he said he would like to. In former pleadings, he's talked about, well, we just got on this case, and I've got Thomas on board, and we haven't had a whole lot of time to get our ducks in a row, and I guess we could toll the time, which is something done in these court cases and stuff. So he had expressed quite clearly that he needed more time. It's just this whole thing, y'all, that Lori wants her speedy trial. Right? And I got to thinking about that. I'm like, Lori wants her speedy trial. Chad waived his right. John Pryor's not ready. John Pryor's probably told Chad, the longer this goes on, the more prepared I will be. and maybe the sting of the fact that you murdered your wife and these children will calm down some after a time. And then, obviously Lori, she's taking an active role, y'all, right? In her defense, maybe she thinks the quicker that she can get her speedy trial, the less the state will be prepared. And, I'll tell you, throughout all of this, since the indictment came down and it became a capital case, a death penalty case, the state has always said that they're ready to go, although they themselves have asked for a continuance and received it. Comes now the defendant through her attorneys and pursuant to the Constitution of the United States, Amendment 6, the Constitution of the State of Idaho, Article 1, Section 13, and Idaho Code 19-3501, moves the court to dismiss this case as the government has violated her right to a speedy trial as follows. And Archie's going to let everyone know why he thinks that she's had her right to a speedy trial violated here. Number one, the accused shall enjoy the right to a speedy trial. Constitution of the United States, Amendment 6. Number two, the accused shall have the right to a speedy trial. Constitution of the State Idaho, Article 1, Section 13 of the state constitution. Number three, since the term speedy trial does not specify the length of time required to bring an accused to trial, federal law enacted a timeline for someone charged with a federal crime, and each state in the union enacted laws to define what it means in their respective states. The Idaho legislature defines speedy trial like this. This is how Idaho's statutes and codes say this is a speedy trial. The court, unless good cause to the contrary is shown, must order the prosecution or indictment to be dismissed in the following cases. If a defendant whose trial has not been postponed upon his application, his or hers, is not brought to trial within 6 months from the date that the defendant was arraigned before the court in which the indictment is found. And that seems cut and dry, doesn't it? That 6 months just kind of just comes out of there and you're like, oh shit, Archie's got a point here. But people forget that the Constitution, the legislature said quite clearly, unless good cause to the contrary is shown. So what that means is Judge Boyce had to, if he was going to postpone this, as Archie lays out in here, he would have to have good reason. And folks, the number one reason is that this is a death penalty capital case. There isn't a more important reason to, go there in terms of, a good cause to the contrary of the 6-month mark. I mean, and not only that, you take a step down from that, this is a joint trial and it involves conspiracy to commit murder. These two cases have been joined. That is another thing that doesn't always happen. It's very important. I mean, you can chisel this down and say simply, well, hell, this is Chad and Lori. I mean, 3 people are dead in Idaho under really egregious, terrible circumstances. 2 children and Tammy Daybell. Yes, of course. But folks, this is also a capital case, as we all know. But Archie wants to, to go into this a little bit. And he talks about State versus Clark. The Idaho Supreme Court took up the speedy trial issue and determination of good cause. Okay, so he's listing out how this all is supposed to be. And of course, bringing it back to the Idaho Code that good cause to the contrary is shown. Judge Boyce, you'd have to believe that he did not have good cause. It's not just about Judge Boyce in the law where he has discretion. He absolutely has discretion. The laws have been implemented, but showing that the judge has discretion, right? But it also adds a layer to that by saying that it is good if a good cause can be shown. And Judge Boyce has made that abundantly clear every time this has been pushed off. But let's get back to the Idaho Supreme Court, who took up this whole idea of the speedy trial issue, all right? Upon careful consideration of the relevant authorities, we believe, and this is the Supreme Court of Idaho talking, we believe that a thorough analysis of the reasons for the delay represent the soundest method for determining what constitutes good cause. So it's easy for KJ to say, well, in that code it says if it has good cause is shown. Well, the Supreme Court is now letting us know, what does good cause mean? We therefore conclude that good cause means, now listen up, that there is substantial reason that rises to the level of a legal excuse for the delay. And folks, again, you have to throw in this whole case file. Every damn time John Pryor has tried to have this case severed, and he's going to try it again on the 9th of February. Every little nook and cranny down to the, it was a couple of months ago, the state said, Judge, at this point, you need to kind of start curtailing this because they're filing this shit left and right. We're trying to get ready for trial. You need to put in there that you need to basically, tighten the belt on what the defense is trying to throw out here. This is all redundant. It's just the same shit, different day. We therefore conclude, again, this is the Idaho Supreme Court, that good cause means that there is substantial reason that rises to the level of a legal excuse for the delay. Because what? Because there is not a fixed rule, y'all, for determining good cause. When you think of fixed rule, you're like, okay, Jay, it's a fixed rule. If she's not tried in a 6-month period, her case can be dismissed. That's what it says in statute. And it does, y'all. But it also adds the good cause in there. Unless. So the Supreme Court lays it all out and says, okay, the statute does say 6 months, but we've got to let you know what good cause is. Because there is not a fixed rule for determining good cause for the delay of a trial, the matter is initially left to the discretion of the trial court, i.e., Judge Stephen Boyce. Okay? The good cause determinations may take into account the factors listed in Barker versus Wingo. This is the Supreme Court saying, here's some case law that we're relying on while we're telling you what good cause means. The Barker factors, however, considered only as surrounding circumstances are important, if at all, only insofar as they bear on the sufficiency of the reason itself. The shortness of the period, the failure of the defendant to demand a speedy trial, which that's not Lori's issue here, and the absence of prejudice are legitimate considerations only insofar as they affect the strength of the reason for the delay. So what the Supreme Court is saying is, hey, first of all, you've got to determine whether they wanted a speedy trial or not. And if they did want their speedy trial, then you've got to look at the substantial reason that rises to the level of what? A legal excuse. And I think Judge Boyce has done this, y'all. Because there is not a fixed rule, and we know this, the bottom line is that The shortness of the period, the failure of the defendant to demand a speedy trial, and the absence of prejudice are legitimate considerations only if they affect the strength of the reason for the delay. In other words, the prejudice to Lori. Well, we know her case is joined with Chad, and John Pryor has said it. He said this would prejudice my client, but Archie hasn't really said that per se. John Pryor's the one that's been wanting to sever this all this time. But if you think about the prejudice and you add on that Lori did not want her speedy trial taken from her, you have to weigh that against the period and the failure of the defendant to demand a speedy trial is not something that we consider. This means, to whatever extent the delay has been a short one, or the defendant has not demanded a speedy trial, or is not prejudiced, a weaker reason will constitute good cause. On the other hand, if the delay has been a long one, or if the defendant has demanded a speedy trial, or is prejudiced, a stronger reason is necessary to constitute good cause. In other words, if Archie comes out with saying, this is her rights have been violated, and he gives her his reasons for that, right? And they're weak reasons. Then the Supreme Court says, then there can be a weak reason that you continue down the road you're going through, Judge Boyce. But if Lori, it's been a long period of time, it's heavier, right? And there is evidence that there's prejudice there because she's joined to Chad, and it's a heavy thing, and Judge Boyce, you seem to see that, and it's heavy, then you've got to give a heavier reason why you did what you did. Thus, the ultimate question of whether legal excuse has been shown is a matter for judicial determination upon what, y'all? The facts and circumstances of each case. A trial judge does not have unbridled discretion to find good cause. However, and on appeal, we will independently review the lower court's decision. So they're saying, Judge Boyce, you can't just decide. You don't have just this ultimate power to put this trial off or, past the 6-month mark. But you do have to show us legal reasons why you're doing it, and also the circumstances. And you also, Judge Boyce, if whatever your reasoning that you've put down that you have changed the dates on this trial and moved it further, you've got to let us know that this did not prejudice this woman. This was not something that was weaker than the strength of Archie's argument. I hope I'm explaining this properly. I know I'm explaining it properly, but not properly, but I'm explaining it out of my own brain. Maybe you can see the forest through the trees on this. Following is the timeline in the case of Lori Vallow Daybell, and Archie lists it all out. I'm not going to go into that. You can, all of us pretty much know that this has been put off for some time. We'll go on to the next. It just basically says when he gives the timeline, 1,169 days in jail without a trial on any of the 3 cases. Then it goes on. The first trial setting in this instant case was for October 11th of 2022, since that was within 6 months of April 19th of 2022. All was looking good, y'all. I mean, he gave her date for her, her trial there. The government then asked for more time, and the court granted the request and set the trial for January 9th of 2023. This violated her right to a speedy trial. Now, let's stop for a minute. Y'all remember back. We found out that, it was going to be a whole nother year. Remember, it was January 9th, 2023, and we were all bummed out. What the hell are we going to do all this time to get ready for this trial? We were so waiting to get this underway. Then it was 2023. Remember that? And the state said, we need more time. Well, the judge sees the legal reason The circumstances being that these two cases are joined, this is a conspiracy to commit murder case. Not only that, it is a capital case. It's a death penalty case. It's some serious shit. And the judge moved it. And let's just also, with a caveat in there at the time, John Pryor, we want our speedy trial. And now here he is coming out saying he wants another continuance till next year. And then, of course, Archie, y'all remember his, we'll just have to toll the time and all this. Lori Vallow Daybell's defense team questioned her competence to stand trial, and the court told the case from October 6th of 2022 to November 15th of 2022, which was a 40-day delay caused by the competency review, still doesn't justify a trial setting 3 years after her arrest and almost 1 year after her arraignment. Well, let's back up, because Archie knows good and damn well that when Mark Means threw Lori's ass in there for 10 months, and then there was another time that Archie, they had that, remember that? All the state law, there was a legal reason they had to do this. They couldn't just say, well, just because you, Archie, or Mark Means, y'all say Lori is nuts or needs her competency sorted out, that we're just going to move forward. No, they had to, by law, by statute, take that time out. So there's your legal reasons for that. But Archie says, well, even though with that time, then we're talking 3 years after that, the government still has an obligation to bring her to a speedy trial, which complies with the Constitution in Idaho Code. Well, again, Archie, he fails to put in there that Judge Boyce he doesn't have unfettered discretion, but he has discretion, and he has to base it on legality, legal reasons. There's got to be a circumstance and a reasoning behind what you're doing. And again, this really comes down to, does the Supreme Court of Idaho, or eventually the federal courts, see that Judge Boyce did not use his discretion properly? I think he's done just fine. From her arrest on February 20th of 2020 until the current trial setting on April 3rd of 2023 is 1,169 days without a trial in any of the three cases. From her arraignment in this case on April 19th of 2022 until the current trial setting of April 3rd of 2023 is 349 days. Obviously more than the statutory 6-month time limit. Her constitutional rights, including her right to be presumed innocent and her right to a speedy trial, have been ignored by the government. It is undisputed that Lori Vallow Daybell has demanded her speedy trial and has never waived her constitutional rights. She is prejudiced every day she sits in jail and unable to post bond. And let me just say this. I just got to say it. Where the hell? Where's her damn fat-ass chin husband in all this? Why can't he help his wife? The one he murdered her kids for. The one he murdered his wife for. Why can't he help her post bond? You know why? Because his dumbass can't post his own bond. Dumbass. The court has repeatedly reminded the government that it will respect her constitutional right to a speedy trial, and you damn right. Judge Boyce has said that all along. He's not only said it, he ain't saying it to be nice. He's backing it up for the reasons, the legal reasons, the circumstances behind it. The Supreme Court of Idaho or a federal court on appeals would look at the fact that they had to get this. There was a change of venue. They had to do all this shit just to get it over there in Ada County. They looking at the fact that this is two defendants that have been fighting tooth and nail. They see the writing on the wall. And Archie, obviously, he is qualified and he understands that he has to do this. But then again, it goes back to that question. It's a very simple question. Why didn't he do this sooner? Why didn't he do this sooner? If he had any kind of rightness about this issue at all. The government cannot show good cause to bring Lori Vallow Daybell to trial over 3 years from her arrest and almost 1 year from her arraignment. Well, I mean, he can say that, whatever the hell he wants to say. But he is basically saying the government cannot show good cause. Well, y'all, I guarantee you the state's going to respond to this motion for dismissal. But you can be damn sure that it was Judge Boyce's decision. So Archie's basically saying, Judge, you ain't had no good reason. You ain't got no good reason at all why you've done this. Well, if you really want to know the truth, you really want to feel more at peace about the stupid-ass motion for dismissal, go back and read Judge Boyce's decisions when he did move it. He gave specific case law. He gave his reasons for what he did. He didn't do it for efficiency or because, it would be easier or it would just be, whatever. He took into account when the state asked for that first continuance, he took into account what John Pryor and them was saying. Hell, John Pryor and them, they said what they said, but they, right before, at the time the state was asking for a continuance, John Pryor was like, we're ready. We're ready. And then, of course, John Pryor's like saying, just because Lori's in the Idaho Department of Health and Welfare this is bad for my client. This prejudiced my client. We need a severance. But then again, the Idaho Supreme Court and federal courts on appeal will look at his actual legal documents before and after where he changes position over and over again. He's 1 minute he's ready. The next minute, he wants a continuance. John Pryor has stated it more than once, but we're not talking about John Pryor. We're talking about Lori Archie. How's he been? Well, he's got it in his legal documents. Well, we're asking the court to toll. And what does the court do? Not only did the court, Judge Boyce, give the state of Idaho a continuance, the government, a continuance, as Archie states in here, but the judge also balanced that out by tolling things for Archie. So he's not doing any more for the state than he's done for the defense. It's just a lot bigger than saying there's a 6-month period in here and you got to do it. It's just not like that at all. This court should find that the government has not met its burden to uphold her constitutional rights. This case should be dismissed, says Archie. And of course he's going to say that. And of course he is. But, play this out. Judge Boyce has ruled consistently that he wanted to keep these cases together. And the reason he did was because the charges in the indictment, conspiracy to commit murder. You see what I'm saying? He understood that this was ripe for these two to be joined together. It was not going to be a walk in the park. Anyone with a legal mind's going to know. Any Supreme Court Justice of Idaho, any federal court judge is going to look at this and look at the totality of the case itself. Every single bit of it. Everything that's happened. The fact that Mark Means has been thrown off the case. The fact that John Pryor says one thing and does another. It's just, folks, the bottom line is Judge Boyce has basically jumped through hoops to measure out equally the constitutionality of the defendant's rights with the rights of Idaho, the state, Rob Wood, Lindsey Blake, and Rachel Smith, to try her and ultimately the Daybells. So I'm just going to touch on these other very quickly. Again, to me, it's something that Archie has to do, but it is kind of late for that now. I guess he just kind of throw it in there because as soon as that mark happened, he should have been filing that if it was that big of an issue. So Archie, he files a notice of hearing to Lindsey Blake and Rob Wood. He says, please take notice that the following motions will be heard Thursday, February 9th. And he lists out his motions, and the first one obviously is the motion to dismiss. But then the other ones, they don't just back this up at all. In fact, it just kind of shows you where Archie's at. Motion for individual voir dire, which means we're moving forward on this trial. So if he really thought he had a snowball's chance in hell of getting this dismissed, why even file this motion? Motion to disclose penalty phase information, which, he needs all of this to get ready for trial. And a motion for pre-selection instruction to potential jurors. Again, he has to do all this, and this is not his first rodeo. It just ruffled all our feathers because on a human level, we know Lori, she can kiss my ass. She should have thought about this shit before she murdered her children. It just makes it look like all she gives a shit about is herself. And this for somehow, on technicality, she gets to walk out here in the world again while her children are dead and in a freezer somewhere. What? She's going to get out of a jail cell? And this is going to get dismissed against her? Is she going to go claim her kids at the morgue? Give me a break. Motion to extend time for disclosure of witness and expert witness opinion and reports and pretrial deadlines is another document. And this one is from John Pryor. And he says, comes now, Chad Guy Daybell, through his attorney, and hereby requests that the court extend the deadline for disclosure of witnesses, expert witnesses, and their respective reports and opinions. This motion is supported by the sworn statement of Greg Hapkin and representations made in the court on January 19th of 2023. The defense today does not possess the two samples of DNA evidence in which all parties stipulated, and he wants to extend these deadlines. But guess what? The state itself, Rob Wood, Lindsey Blake, notice of hearing, discovery disclosure. The state has, this is on the portal, first and second stipulations for consumptive testing and forensic evidence. The same shit he says he doesn't have, the state now gets in here and gives another disclosure. They gave the Idaho State Police Forensic Services Forensic DNA Report number 15, and Report 16 is exactly why he wanted deadlines instituted. And this is just going to blow your mind. He says, and you can go on the portal, and I'll list the portal. That way you can go through the case file. When I get off here, I'll put it on the community wall. He confirms, John Pryor confirms, that he has sent the state through a private service. He has sent the notice of alibi for Chad Daybell. In other words, y'all, remember when Lori sent her notice of alibi? They filed that one, and we were able to read it. It was short and sweet. But John Pryor now says that he has already given the state Chad Daybell's alibi, and he doesn't want any of us to see it. But the state knows what Chad Daybell's alibi is. And by the way, when I post the portal on there, the state has responded to Lori's alibi by saying, we want specificity. There's nothing in her alibi that tells us times, dates, or anything. So that's a big bombshell. A big bombshell. And of course, we got the usual shit that John Pryor files, motion to sever. He's going to try it again. I do believe him and Archie are kind of working together in a sense. Strategy-wise, I think that's what they're doing. Because on one hand, Archie's nudging at the judge by filing this to say, you got to dismiss this against Lori because of the time frame. And Judge Boyce is also here at the same time that he wants this case, that John Pryor wants this case severed. It's a fight to the trial date of April 3rd of 2023. I will repeat what Nate Eaton says when he talked about Lori's dismissal, and that this is all just formality. But again, the bottom line is the state of Idaho has got a vague alibi that Lori has presented that she didn't know before, she didn't know after, she wasn't the principal offender, and that the children died in Alex's apartment with no damn details whatsoever. And then John Pryor showed on the portal, he did file that he privately gave the state Chad Daybell's alibi. So we might not find out about what Chad's alibi is until the trial. Why? Absolutely why would it be public knowledge and a court document of Lori's alibi? Just a little one, really. Why is that something we can read, but we cannot read Chad Daybell's alibi? Leave your comments. The next time we get together, OKJ is going to give you my view of Chad Daybell's alibi, whether I can see what John Pryor and him thinks is, if it's anything like Lori's alibi, this is a crock of shit, really. Leave your comments. Tell me what you think Chad Daybell's alibi is. I'd love to hear from you. I can't think of everything, and I know y'all have got some ideas, some theories, some hypotheses. Let me know. I love you all. And Chi-Chi's trying to jump up in my lap. Well, don't get mad at me. Don't get mad at me for picking you up. I hope all y'all have a great weekend and keep on looking.